Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone else in between. My name is Dan Balkaran, and I'm going to be your employment lawyer for the next 30 minutes or so, answering all of your questions about all things employment law. Just a couple housekeeping items before we get started. As always, we have a whole variety of resources up at employmentlawyer.ca for your assistance. You can reach us at help@employmentlawyer.ca, and you can call us at 1-855-821-5900. Okay, so why don't actually I haven't introduced myself, or I have introduced myself. I said I'm Dan Balkaran, but I did not say who I am. I'm an associate at Samfiru Tumarkin LLP, which is the nation's leading employee side employment firm. So, roll your questions in. I'll get through as many of them as I can. And a lot of great questions over the last few sessions. So, looking forward to them a lot. So, okay, Tina asks, can your job be changed upon returning from maternity leave? Well, that's a great question. So, in every province, your employment, regardless of your level of regulation, provincial, federal, your employment is subject to a human rights code. It'll either be the federal human rights code, or for the vast majority of you, it'll be a provincial human rights code. And all of them say you can't be discriminated against on the basis of sex, which covers pregnancy and maternity. And so it's sort of the details matter here, right? The facts matter. How long after your maternity leave was your job changed? Is your job materially different in a way that is problematic? Like, is your job hollowing out? Like you were the manager of 2 departments and now you're the janitor. What is the decline you're experiencing? Did your wage go down? Did it happen? I think I said this already, but it happened. Hey, Tina, you're back, and you're now in a worse position, and we're not paying you as much money. So that would definitely be discrimination. And then the question is, what do you want to do about it, right? And so you're going to have to talk to a lawyer on this one. You do have a right of complaint before the Human Rights Tribunal, but what do you get? Well, human rights damages tend to be small, a few $1,000s, here or there. They're generally sort of better used to assist a wrongful dismissal complaint. So the question there for you is, A, have you been constructively dismissed by your demotion, or whatever has happened to you? And that's an assessment of the facts. And listen, you'd be very sympathetic before any adjudicator, because you were on a maternity leave to have a child, and then you came back and they hollowed out your job, or whatever it is they did. So A, have you been constructively dismissed by their actions? And then B, if you have been constructively dismissed, what is your severance right? And so if you have an employment contract which limits your termination rights to whatever the minimums are of wherever you are, most likely the employment standards minimums, then you wouldn't want to do it, because 5, 6, 7 weeks, whatever it's going to be, probably not worth it. Rather keep your job, maybe, right? But if you've been there for 25 years, well, I mean, be a more realistic scenario, but you've been there for 10, 12, 15 years, you have no employment contract, and maybe you want to take this time to step out with a bunch, and take money on the way out. So you've got to assess that now, or if you just simply don't want to lose your job at all and you'd rather stay, but you just want to force your employer to behave better, then it's a goodwill situation, or you're trying to trade on your goodwill, and maybe a notification to your employer saying, hey, I'd like my old job back, etc. But that's always dangerous, because if you poke the employer the wrong way, the employer may not want to continue with you, or you sour the well with them. And so it's kind of a balancing of internal politics versus, which only versus legal obligation, which is what a lawyer knows. So I would certainly kick the tires, Tina, with a lawyer. I think you should do so. If you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, Leo asks, I worked afternoon shifts the first 2 years of my job. Now a new supervisor is saying that due to understaffed night shifts, I have to take the occasional night shift. Do I have to accept? So it's not a matter of accepting. Like, unless your employment contract says you are only going to work a certain schedule, then if your employer asks you to do something reasonable, like work different shifts, if you don't accept, you've effectively resigned, because, or a better way to say it is, I shouldn't say you've effectively resigned. You've committed insubordination, which is tantamount to just cause. I would think, I would look at it that way. And so, if they ask you to take on the occasional night shift, it's also not that onerous, right? It's not like we're putting you on graveyards and you'll never see your family. It's so. No, you don't really have a legal means to do something about that if you're a non-union employee, okay? But the question is, well, one, can you deal with it amicably with this new supervisor? And two, how much do you want to be in this job for? Because you've only been there for 2 years. It's an incredibly hot labor market right now. I know it's cooling off, and certainly in some sectors like technology, it's really cooling off. So it's an incredibly hot labor market. And so maybe you want to vote with your feet and just, you throw out a resume, see what's out there, maybe you move laterally with a raise. And then it's because it's not like you've got 12 years of goodwill in the tank there. Or, and this is probably what I'd be inclined to do, if it's accurate, if there's a medical reason why you can't work graveyards, okay, I would go get a doctor's note, assuming there is one, right now, saying, Leo is unable to work, medically unable to work graveyards. And I would give that to my employer right now. Then they can't put you on graveyards without violating the Human Rights Code. And if they do, you then have a constructive dismissal. But again, as I said to Tina, constructive dismissal is just, I'll back up here a second. In order to get severance, you need to be terminated. Constructive dismissal is a way to get to termination without your employer actually saying, hey, you're fired. Okay, it's the actions of the employer are tantamount to a termination, therefore I've been terminated. Okay, and so in that situation, if they were to place you on graveyards, you'd certainly have a human rights complaint, and you could certainly claim, well, I can't medically, so they've terminated me by their actions, and I put them on notice. So if there's a medical reason why you can't work graveyards, I would get that note right away and provide it to them. I will say this though, I can't say that. I will say that if your employer wants you to work a substantial amount of graveyards or night shifts or whatever, and you provide them a note saying, I can't work graveyards, medical note, all the other guys who then have to work more graveyards because of you, number one, they're not going to like you very much. And number two, the employer they're not going to want you to be there, most likely, down the road, right? So you've got to balance all these things and figure it out. I will also say though, said it's a couple graveyard or a couple night shifts, the occasional night shift, maybe, but it also could be a beachhead. Employers quite often, they say, hey, can you take this on? It'll be on a temporary basis. And they're like, this is still working. Resources are tight. This is just your thing now all the time, right? So it's a tough situation, Leo. I don't know. I mean, I've given you the sort of the law and the employment background of it. You'll have to make your own choices up in terms of what's the best thing for you. Kevin asks, currently on short-term disability with my employer. Today, the employer asked for a doctor's note indicating my absence, or if I don't mind sending the diagnosis through the short-term disability form, am I obligated to send these? The employer is on short-term disability, which has been approved. Well, who handles the short-term disability? Is it your insurance company or is it the employer, right? Because a lot of times employers will pay for the short-term disability themselves, and then the insurer will pay long-term disability. So, well, first of all, there are two different things, right? So, one, you're on medical leave, okay, and it's been properly papered, and you're on medical leave. And two, in order to get money while you're on medical leave, you're getting short-term disability. Those are different things. And so, let's just say you weren't getting the short-term disability. Would you have to provide a medical note to your doctor to say, yeah, I'm properly unable to work? Yes, 100%. Okay. So they're entitled to a doctor's note saying, hey, I can't medically work. And so if they're asking for one, provide it to them. It only helps you. It just papers unless you can't get it. But if you're on short-term disability, you would have had to have had a medical note in the first place to get there. So, I don't really know what the issue is, but if an insurance company is handling your short-term disability, certainly you can just talk to your short-term disability provider and they will provide a medical note. But what you run the risk of is eventually your employer saying, well, you've quit because we don't know if you're medically unable to work. I've encountered that before, where I've talked to employees who were provided ample notice by the employer, hey, we don't know if you're properly away or not. You've told us you're ill, but we've got no objective professional backing here saying that you are. So just provide us a medical note. And the person didn't provide a medical note after several requests. They said, you quit, you're done. And that person, in fact, did quit and was done. So they're asking for a medical note. Like, medical notes don't have to go into detail. They don't have to say, Kevin has XYZ condition. Just say he's it's in my care. He's medically unable to work for X amount of time to be reassessed in 3 months or whatever. Just get one of those, send it to them, or provide it to your insurer and have the insurer send it to them. But then, I don't really understand the distinction, Kevin, and why you're concerned about it. It's medical notes. Like, if this becomes a problem down the road of significant dispute, the medical notes are like a trail of breadcrumbs that help you out. So they can only help you. So I would certainly get one, and I'd provide it to them, and I'd provide it to the insurer, and I would, every single time that medical note expires, I would do it again. So medical note expires in 3 months. You want to stay on your medical leave, do it again. So I don't understand. Like, I don't understand what the issue is, Kevin. Maybe you can elaborate further, but yeah, do it. If the issue is you can't get a medical note, I guess you could go to a different doctor. But if you can't get a medical note, then you've got a larger problem, which is, why are you on short-term disability if you're able to work? So, that's my answer, unless you give me more information, Kevin. Joel asks, can you be fired for asking for a raise? All right, so the short answer is you can be fired for anything. They can fire you, barring a human rights protected ground. So they can't fire you because of your race or your sex, your gender or gender identity, or any protected ground. Okay. Or disability. They can't fire you because you broke your arm, and are unable to work. Although the remedies for that aren't necessarily the greatest, but other than that, they can fire you because they don't like that your car is blue. Right? They can fire you for whatever reason they want. But in order to do so, they need to provide you with severance. Your only legal right in the event of your termination is severance. But it's the amount of your severance that matters, right? And the amount of your severance is complicated. That's why we have these Facebook live chats and other reach out engagements. But your only legal right in the event of your termination is severance. The amount of your severance is what matters. The amount of your severance for 95% of you can come from two places. It can come from the Employment Standards Act, which contains the minimums you're entitled to at law, which are not very generous. roughly 1 week per year of service to a maximum of 8 weeks. Or they can come from the common law, which is a fancy term for judge-made law, which is decisions by judges over time about severance. It's much more generous, like a 4 times multiple. So that's where you want to be. And I think I said it already. What determines whether or not which regime you're under comes from your employment contract, and then your age. If you're under the common law, your age, your length of service, and position, and how long you're unemployed for. But it can be quite lucrative. It can be a best day, depending if you've been there for a long time, of 24 months. So of your wage. So that's why it's certainly worth investigating. Your question was, can you be fired for asking for a raise? You can be fired for anything. So, but it's just, what is your protection on the back end is severance. If your protection on the back end is you get maximum of 4 weeks, then you've got to evaluate that. So, if you want to have maximum information before you go into this, then you can talk to an employment lawyer, and the employment lawyer will let you know what your best day scenario is in the event of your termination. Again, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 if you want to get a hold of us. I'll tell you this: if you're a 25-year employee and you're 55 years old and you're making $100,000 a year and you have no employment contract, you are not fireable. I mean, if they do, it's a disaster for the company and financially. So then ask for the raise away. I will say this: it's extremely hot labor market, as I said earlier, Joel. So for everyone, now's the time to ask for raises. In BC, where I am, I'm called to the bar in BC. The news has been filled with over the last few weeks with unions, threatening strikes and going on strikes because they want more money. Because they should be doing that in terms of their negotiating position. I'm not commenting on it politically or the inconvenience of everybody else, but there aren't enough employees around post-pandemic. So now's the time for every employee to squeeze their employer for more money. I think the same thing. I was in Toronto in August for a week, and I think the same thing's happening out in Ontario. So yeah, if you're going to ask for a raise, you can never ask for a better time than right now. Helen asks, a dismissal involves age and sex discrimination plus retaliation. Should I sue in Supreme Court of Human Rights? Pros and cons. Where do I have more profitability to get more punitive compensation? Well, that's a lot of different concepts sort of interchanging here. So you got fired because of your age and your sex, and they retaliated against you for something that we don't know about. So I don't know where you are. If you're in BC, you likely sue in Supreme Court, and you'd file a human rights complaint, and they'd sort of work together to assist you. Okay, so it's not an either or thing. If you're in Ontario, and don't quote me on this because I'm not called to the bar in Ontario, but I believe you can combine them. So in BC, there's exclusive jurisdiction for the Human Rights Tribunal, and you cannot, your lawsuit cannot trench on the jurisdiction of the Human Rights Tribunal, which is 100% exclusive. The human rights damages are separate, non-taxable damages, generally speaking. But the two things tend to work together, even in both jurisdictions. And sorry for the rest of Canada, it's not BC and Ontario. I can't comment. So I don't think it's an either or thing. I do think you've raised a bunch of issues, Helen, so you should 100% talk to a lawyer. The value in your claim is depending on the egregiousness of the age and sex discrimination and retaliation. Is going to be from your wrongful dismissal, and so that's going to depend upon a variety of things. So, like I've talked about earlier. So, yeah, give us, if you want to talk to an employment lawyer, you should talk to an employment lawyer. If you want to get a hold of us, you certainly can at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, Paul asks, is it legal for an employer to refuse to let you take a meal break during the day? My sister works 10-hour shifts, and her manager says she's not allowed to take a meal breaks due to short staffed. Okay, so I'm guessing your sister works in the restaurant industry. I've never understood how that works. I've known lots of people who worked in the restaurant industry, and from servers to line cooks, and they all say the same thing: I don't get a break. It's just too busy. It's not legal, right? So, Employment Standards Act, if you're provincially regulated, which most likely your sister is, guarantees amount of breaks. I can't remember the exact. It's not something I deal with on a daily basis, but I think it's, if memory serves me, it's half an hour lunch unpaid and 2 15-minute breaks paid is your legal entitlement in BC anyway. It'll be in the Employment Standards Act, but no, it's not. But I'll say this: despite it being illegal to do that, I do know that almost all restaurants do that. So she pushes too hard. Like she says, I have the Employment Standards Act, and it says, I need a break, etc. How long will she work there for? Is it important she has that job? These are political considerations you have to consider. If she's not getting breaks, what's her remedy? Well, you can't get a lawyer involved for that. Is there any, she could claim that she was constructive. Like if they fire her for that, what's her severance? Then it goes into the evaluation I talked about before. She should talk to an employment lawyer. So, you've got to balance all these things and then figure out exactly what you want to do. A sneaky way around this, again, depends on what her medical conditions are. But if a doctor writes you a note, like if she goes to her doctor and says, listen, again, she can't just make something up. It has to be factually accurate. You should never lie to your lawyer, and you should never lie to your doctor. Okay. But if she's having genuine issues, the 10-hour shift's a long time without eating. I couldn't do it. I'd pass out. So if she's having issues, say, with functionality or sleep or hypoglycemia or diabetes or energy or whatever, her doctor is going to write her a note saying this person needs to eat, every so often. She provides that note to wherever her employer is. What's her employer going to do then? Not let her take a break? They'd be in the human rights violation. It's probably what I would do in that situation. But again, if you do that, employer is not going to be favorably disposed to your sister. So listen, I wish your sister the best of luck with that. I will say, it's not a good idea to work for 10 straight hours without eating. So I would just leave it at that. Phoenix asks, what can I do if my employer won't let me resign? Sorry, I shouldn't be laughing. If your employer won't let you resign, that's not a thing. I heard a story once about an individual who tried to break up with his girlfriend, and the girlfriend just refused to allow the breakup, so they stayed together. Like, well, that's not how that works. If one person says I'm done, you're done, right? So if you resign, then you've resigned and just move on, right? Like if you don't want anything from your employer, then you're done, right? Like just I'm going to quit in 2 weeks or whatever your notice period, your resignation period is, and then go do something else. What are they going to do? They don't have any legal entitlement against you. So, yeah. So Helen says, and sorry, Phoenix, I didn't mean to laugh. I've never heard of that before. And I thought the reason why I was laughing is I was laughing at your employer's chutzpah, we'll say, for the boldness of your employer for telling you can't resign. You can do whatever if you don't want anything from your employer, you can do whatever you want. You can resign. Helen says she's in BC. Helen was the one who was asking about the human rights complaint in Supreme Court. So Helen, you do both. But it's complicated. I wouldn't encourage you to do it on your own. I think you should get a lawyer. I think you should get a lawyer, and then it's not me. Sorry, you can reach us if you want. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, Kate says, after sending in a doctor's note to my boss, I was told there was no modified work available and I should return when I feel better. Does this count as a layoff? Oh, it's okay. So Kate, the legal test is your employer must accommodate your medical disability to the point of undue hardship. Okay. And so if they haven't, then if they're saying, no, we have no modified work available, it's possible that you've been terminated. If they haven't offered you anything and just said you don't work here anymore, then yeah, I'd say you've been fired. Okay, and you should talk to a lawyer immediately, and the lawyer can assist in evaluating whether or not you have a claim. See the information on the screen. Helpemploymentlawyer.ca 1-855-821-5900. I mean, I don't know anything about your medical condition. I don't know if this is a transient thing. Like, listen, if you're going to be ill or unwell for a month and then you're going to come back in a month, then maybe you stick it out, right? And you go back. But if this is a thing where you're going to have 70% functionality in your back for forever, and you need to be in a job that you don't lift as much, then you're going to need those modifications, right? And so then the test then for the employer is to prove that they can't. It's a hardship for them, an undue hardship for them, to be able to provide modified work. Now, if you work in a retail store, for example, it's going to be impossible for them to do, and so you've got a good severance claim. And so the burden is on the employer to prove that. It's a tough burden to surmount. You probably have a claim. You have a good claim in the event that this isn't a situation where you can go back to work in 3 weeks, and you need sort of an ongoing permanent accommodation. And they've just said no. But of course, it all depends on what the details are. So you definitely should talk to a lawyer, Kate. Especially you, of all people we've talked to so far, or of all the people I've talked to so far, definitely need to talk to a lawyer, because you need to assess things right now to determine whether or not you've been terminated. You don't want to run the risk of, especially if they keep you on benefits, for example, you don't want to run the risk that they have effectively placed you in or that you have deemed to have accepted alternate terms of your employment. So now you're just in a holding pattern of layoff or medical leave, but getting benefits, and that precludes you from claiming constructive dismissal 5-6 months down the road. So, Kate, you need to talk to a lawyer immediately. I'm not going to say this person's first name because it's unique, and I don't want to identify him or her. Hospitality staff get breaks during downtime. From what I understand, if we've worked several shifts under the knowledge of not getting breaks, that we're stuck with that standard. Is that true? No, absolutely not. So the floor of your legal rights is going to be enshrined in the Employment Standards Act or the Canada Labour Code, depending on if you're federally regulated or provincially regulated. If you're hospitality staff, you're going to be provincially regulated, which means go take a look at the Employment Standards Act, and it will tell you what your legal rights are with respect to breaks. This is the same question, I think, that we were talking about earlier. But the idea that you don't get breaks if you work several shifts without taking a break means you're stopped from claiming you get a break in the future no, it's just not legally a thing. That just sounds like something that employers tell their employees in order to not have them go on break. It's just a clever ruse. So, again, it's the same balancing act that you have to strike, as I talked about earlier, which is, it's your legal rights versus what happens to your job in the event that you push back hard enough, right? Like like I said, you can be fired for any reason. Just depends what your severance entitlement is flowing from that termination and whether or not that's worth it for you. But again, to all of you, it's a historically hot labor market. So if you're going to push for a raise or change horses, go to a different job, now's probably the time to kick the tires and all that stuff. And I'm not giving you any specific advice about what employment decisions you should make. Okay, I'm just saying that when labor markets are tight, you have more leverage. Okay, so I'll just say that. But other than that, I think that's all the questions. We got through them all today. I wish you all a wonderful and safe weekend. Thank you for joining us. I'll just the last couple things. I saw the Chiron on the stage or on the screen, but I wasn't able to get to it. Maybe we can get that up again. It's Chris Justice. Join us for next time for Chris Justice. It's at 1:30 Eastern time, is it? I think it's there. It is 1:30 Eastern time, Monday, September 19th, with Chris Justice. He'll go over all things employment law with all of you. And as always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thank you for all the wonderful questions today. You will have a wonderful and safe weekend. I'm Dan Balkaran. Until next time, join me in 2 weeks. Thank you.